Okay, very good evening, students. Good evening, everyone. Very good evening, Shivangi. Please confirm about the voice and the video, and after that, I'll start the session. Chaliye. Thank you very much for the clarification. On that note, let's begin with this session. So, first of all, I welcome each one of you to my class on process to compel appearance. So let's start with my brief introduction first. My name is Sandeep Khatri, and these are my areas of specialization. As you can see on the screen as well, the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, I have shared the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. After that, I have shared the link of my Telegram channel where you can connect with me and ask your questions related to your judiciary preparation. And at the end, that is my code Khatri10, which you can use to get free access of all the special classes available on Unacademy app, and also to get 10% discount on all your plus courses. So this was about me. So I request now everyone, please be attentive, and this is going to be an interactive session. So the moment you feel you're not clear with anything, feel free to ask your questions in the comments and I'll answer accordingly. So students, before starting the session, if you have any doubts, you may ask. If you have any questions in your mind relating to CRPC, relating to this topic, you may ask. And if not, quickly give me a thumbs up. I'll straight away start the session. Very good evening, Alaiva. Thank you very much for the confirmation. Okay, Shivangi and Alaiva or any other students, if you have any questions in your mind, you may ask. And if not, quickly give me a thumbs up. I'll straight away start with the session. Okay, Shivangi, anything from your end, Alaiva? Okay, I have got the thumbs up, which means no questions at all. So I'm straight away starting this session. First, let's understand the topic, what the topic which we are going to deal with. So the name of the topic is, students, when it comes to CRPC, how you can compel the appearance in the court of law. How you can compel the appearances. So in this, the chart goes like this. The very first one, the very first process, when the court wants your presence, that is through summons. Now what after summons? Or what if summons doesn't work? Or what if the court don't want to send summons? In that case, the court will go with an option called warrant. Okay. What if summons fail? What if the warrant fails? Then what? Then there is a concept of proclaimed offender. Now, what if even, after pronouncing the accused, the proclaimed offender, if that person is still not coming into the courts, then what? After that, we do have an option of attachment of property. And what if not even after attachment? Then we may sell the property. So as far as CRPC is concerned, students, there are these concepts starting from summons. So first we need to know what is summon, how summons may be served. Then there comes the concept of warrant, then the proclaimed offender. Now who is proclaimed offender? who can attach the property, what is the role of district magistrate thereon, then can you sell the property. Now in between there is again a concept of claim and objections, and what if someone's claim or objection has been failed, can that person file a suit as well? So that the answer is yes, you will get 1 year of time period. So in between there are the concept of attachment, sorry, in between of this attachment of property and the selling of the property, there is one more concept, which is basically where the person can claim the property, right? So this is basically, this is overall chart where under CRPC appearances may be compelled. Any questions from this chart? Now I'll move into the details of each one of these topics. Yes, please. Shivangi, by summon, proclamation, attachment, warrant, scissor. Okay. Now coming to how summons look like. So if you want to see summons, students, I can refer you schedule 2. So in CRPC, okay, I have not got questions, anything till now. Students, any questions before till this chart? After that, now I'll move to the next one. Any questions till now? If not, quickly give me a thumbs up. I'll move into the details of this topic now. Okay, I have got the thumbs ups. Now moving on. Now coming to how summons look like. So here you can refer the schedule 2. When it comes to CRPC, there are two schedules. The second one deals with the forms. Now how many total forms there? Total 56 forms. When you will look into form number 1, that is basically of summons, and form number 2 is basically of the warrant. Okay ji? So form number 1 here of the schedule 2 and form number 2 deals with the concept of warrant. Now coming to summons, section 61 till section 69 of CRPC deals with the concept of summons. Now what are some essentials of the summons? Let's start with the essentials of the summons. And let's discuss one by one all the important essentials, all the important questions which you may expect in your exams in relation to this concept. So the first thing is, who may issue the summons? So the answer is, as per to section 61, only the court may issue the summons. Now how? It must be in writing. Summons cannot be in oral forms. Okay, so it must be in writing. And who can send summons? That is the court. Now coming to the third point, it always must be in duplicate form. Now the question is, sir, why there is a need of duplicate? The reason is, when the court will issue summons, so suppose this is the summon and this is the duplicate copy, so it must be there must be a duplicate. The reason is, the one will be delivered to the accused, right? And the second one, the accused will sign on it. So basically that will work as an acknowledgement that yes, I do have received the summons. Okay, and that is the reason that as per to section 61, one of the essential is that it must be in the duplicate form. Continuing with the next one, it must be signed by the presiding officer of such court. So in every court there is one officer that is for that purpose ki okay, whenever the summons are going to be issued, that person is going to be signed, and that person, as far as 61 is concerned, will be called as presiding officer of such court, or such officer as the high court may. Okay ji? So the high court of one respective state may also select that person. From time to time, by rule direct, and shall be a seal of the court. So there must be a seal as well. These all are the essentials of the summons, which is basically the meaning under section 61. So that was essentials 1. Now coming to the next question. How you are going to send the summons? Okay, how the summons will be delivered. So when it comes to section number 62 till 69, these are basically telling you how you can deliver the summons, how the summons will be served. Now, as far as section 62 is concerned, there must be It may be through police officer as well. So police officer may also issue the summons. Any questions till now? Now I'm looking into your questions. Okay. Okay, no questions at all. Moving forward. Now coming to one important question, students. When it comes to accused, okay, can accused be a company or a corporation? The answer is yes. Even a company or corporation can be an accused of an offense. Now I want you to take to explain the next concept. I like to take you to the IPC class, where in the introduction you must have read this topic. What are the essentials of a crime? And when you answer this question, what are the essentials of a crime? The very first essential is person. And when it comes to person, the term person has been defined under section 11 of IPC. So under section 11 of IPC, person includes company and corporations as well, whether incorporated or not, body of persons and so on. Fine. So in short, even a company can commit offenses. So what if the accused is of company, then to whom you are going to deliver the summons? So the answer lies in section number 63. It says if the accused is a company. Now company is basically a juristic person, right? That is not something which is a natural person. So to whom you are going to give? So there is a list given under section 63 to whom you can deliver the summons of. So to that list is basically the secretary, the local manager, or the principal officer, or to the registered post. Okay, ji? In short, you can send your letter by the registered post to their chief officer. So this is the list: the chief officer, the manager, the secretary. You may send any one of them, and that will be deemed as a delivered. That will be deemed as a summons has been delivered to the company itself. So that is basically the purpose of section number 63. Now coming to the next one. What if the person has not been found? So if there is some natural person and that person is not found because of any XYZ reason, there can be two circumstances in those cases. The first one is very simple, that the person is in. Okay. The second one can be that it is because of the circumstances that the person is not available. So what basically then you can do? So as a general rule, the summons must be delivered to personally to that person only. But if that person is not available, then it can be delivered to any family, any adult family member as well. But that must be adult male member. See, when you are going to read the same concept in CPC, the summons, there you will find only any adult any adult member when it comes to CPC. But when it comes to CRPC, that specifically mentioned some adult male member. And mind it, as far as explanation is concerned, servant will not be included in that list. Okay, ji? Now coming to the next one. Now, what if even that adult male member is also not available? There may be circumstances, there is a complete lock. The neighbors have no idea where they have gone, they have not been contacted. So in that situation, the last option that has been left is that the summons will be pasted on any conspicuous part of the house, which is basically the front gate, and that will be deemed as a summons have been delivered. So this is basically your section number 64. Read with section number 65. Now coming to what if the summon needs to be delivered to someone who is a government servant. So in that situation, whosoever is the head of that department, summons will be delivered to that person, and that person will further deliver the summons to the person concerned. So that is as per to section number 66. Now, when it comes to section number 67 and 68, they will be read in the cases of if the summons needs to be delivered out of the state, which means out of the jurisdiction of the court. If the summons needs to be delivered, so then there is the procedure that needs to be, then the magistrate of the local jurisdiction under whose the person is available the summons will be delivered to that concerned magistrate, and then the magistrate will further deliver that to the person who needs to be summoned. So that is basically the concept of summons. The last section is section number 69, which is basically how the summons will be delivered to the witnesses. So that may be through the registered post, which is basically by the speed post from the post office. So these were your section number 61 till 69. Any questions from the summons? After that, I'll move to the next topic, that is warrant. Yes, please. If it is all clear, quickly give me a thumbs up. If you do have any questions, please ask. Shalja Jha. So I want to take subscription, but what features are available in Plus subscription? Shalija, you will get all the subjects classes, all the subjects live classes in your Plus subscription. You will get MCQ test series. You will get your mains test series. You will get all the test series related to your current affairs as well, related to your language paper as well, and you will get the interview guidance as well. So this is basically the brief which you will get through the bundle of the subscription. I hope I have answered your question, Shalja. If you still have any doubts, you may ask. Okay, I have got the thumbs up, Shivangi. Okay, now moving to the next. What is warrant? So basically, the major difference you can say in a layman's language when it comes to these two concepts, summon and warrant. So summon is a kind of a request that okay, this is what all is. Key, this is the date, this is the time, this is the court you need to represent, and this is the case which you are concerned with. But warrant is something which is basically kind of now the police officer or any other officer, which has been generally it's police officer, but it is as far as your theoretical concepts are concerned, it may be any other person as well authorized by the court who may execute the warrant. But generally, it's a police officer. So basically, when it comes to the police officer, he will come and he will say, okay, I do have an arrest warrant for you. And then the police officer will take that person to the court. So that is the concept of warrant. And this is the major difference between these two concepts, summons and warrant. Summon is basically kind of a simple request. Warrant is when someone force you physically, when someone arrest you physically and then represent you in front of the court. So that is warrant. When it comes to warrant, the sections are, it starts from section number 70 till this is your basically 81. So 70 till 81 is basically your all the provisions are related to the concept of warrant. Now coming to the first, what are the essentials of warrant? So very first thing, if you want to see how warrant looks like, then you may refer yourself to the form number 2 of the schedule 2. Okay, then you may see, okay, these are the columns, these are the writings. So there is a format that has been given. So form number 2 deals with warrant. Now coming to what are the essentials of warrant. Now first basic question. You know, in summons when we did section number 61, it was basically that you need in duplicate, right, when it comes to summons. So is it the same when it comes to warrant as well? Do you need warrant in duplicate? The answer is no. Now why no? Why don't we need a duplicate warrant as well? So the reason is again the difference which I told you. In case of warrant, unless it is a bailable warrant, so unless it is a bailable warrant, the police officer will take the person. So there is no need of any kind of acknowledgement. So there is no need of duplicacy. Now coming to the other important essentials of warrant as per to section number 70 are, first one, issued by court. So who may issue warrant? The answer is only the courts. Okay, so the police officer, when it comes to section number 61 or section number 70, they cannot issue summons or warrant as far as 61 and section number 70 is concerned. Okay, now coming to the next one, it must be in writing. So it cannot be in oral form, right? There must be in written form that you can see, okay, see, here is the warrant. Okay, if suppose there is a Mr. A and the police officer is saying you are under arrest because there is a warrant for you, so that accused has all the rights to go through with the details of that warrant. Okay, So the next one is, it must be again signed by the presiding officer. So whosoever has been appointed by the court, so that there is going to be signature of that person, and shall bear the seal of the court. There is going to be seal as well of the court. So every such warrant. Now, when it comes to warrant, now we will study in the upcoming sections that who is going to execute the warrant. But before that, there is again one more important question which is usually asked in your exams repeatedly, and that is key. Once the warrant has been issued, what is the validity of that warrant? So let's take an example. If now the police officer do have the warrant on the name of Mr. A, and the police officer first went to the place of business of Mr. A and he was not there, then to his home, or or where he maybe possibly can be present at that point of time. But if the police officer cannot find that person, so what is going to be the validity? So the validity as far as section 70 clause 2 is concerned, that must be until arrest. So there is no time limit. So until arrest, or in the second case, when it is cancelled, by the court, okay, or it may be executed. But as far as the practical examples of this situation is concerned, the thing is, usually it is advisable, if the person got to know that the warrant has been issued, the best advice can be given to that person is that do surrender yourself to the court as soon as possible. Okay, so the validity is until it has been cancelled by the same court that has issued the warrant, or it has been executed. Okay, so that is the validity of the warrant. Now, any questions from the introduction of the warrant from the form number 2 or from section number 70? If you have any questions in your mind, you may ask. If not, quickly give me a thumbs up. I'll move to the other provisions of warrant. Shivangi, I have got your question. Can be executed at any place in India? Yes, the warrant can be executed at any place within the territory of India, not outside India. Okay, you cannot issue warrant outside India, but within the territory of India, it can be executed. Okay. You can refer section 77 as well for this question, Ashwangi. Where warrant may be executed. So as per to section number 77, a warrant of arrest may be executed at any place in India. So within the territory of India, you may execute that. Anything else? Yes, valid until executed or cancelled by the same court. If the court cancelled it for any good reasons, then also the warrant will be not effective. Okay. Okay. Any questions, Alaiva? Okay, Piyush Mani Tripathi, your question is who issue the warrant? So the answer here is the court, the criminal courts here basically. And who are criminal courts? Piyush. So the term that has been used in section number 70 is the court. Now, when you are going to go into the details of that term, the court, you may refer section number 6, read with section number 26. They are the courts basically we are dealing with here. Anything else from anyone? Feel free to ask your questions. This is your opportunity. This is your time. Okay. I hope I have answered your question, Piyush. Anything else? Okay. Thank you, Alaiva, for the confirmation. Thank you, Alaiva and Shivangi. Now I am moving to the next one. Now coming to warrant. When it comes to warrant, there can be of two kinds. Now listen this carefully. When it comes to warrant, you can divide the whole concept of warrant into two kinds. First one is bailable warrant and the second one is non-bailable warrant. You must have heard about NBWs, okay? It's a most common word when you may have heard about it if you are practicing law or if you have done any kind of internships in the criminal law, okay? So what is this bailable warrant and non-bailable warrant? So suppose this is your warrant, okay? In this warrant, if there is a clause that you can deposit 5,000 rupees or 10,000, any amount given in the warrant, If you deposit that amount to the concerned police officer, then the arrest will not take place. So basically, it means if there is any clause in that warrant, you will call that bailable warrant. And what if there is no such clause in that warrant? It means it is non-bailable warrant. Now, who is going to decide this question? That, sir, in what cases this is going to be bailable warrant and in which cases this is going to be non-bailable warrant? So the answer is again very, very simple. The court only will decide. Now the question is, let's go further. Let's go further. How the court will decide? How the court will decide? Can anyone wants to answer this question? How the court will decide that they should go for bailable warrant or they should go for non-bailable warrant? Yes, please. I hope my question is very, very specific. How the court who is issuing the warrant under section 70 will decide that they should go for bailable warrant or non-bailable warrant? Anyone? Yes, please. Yes, Shivangi, that bailable warrant may be with surety and without surety. Okay. Waiting for my answer. Yes, Shivangi, Alaiba, Piyush, waiting for my answer. How the court will decide that they should issue bailable warrant or non-bailable warrant. So we are basically discussing here section number 71. And let me clear this, you will not find the answer of this question in the Bail Act or any of the textbooks. Okay, now I'm answering this question. Listen carefully, students. So the court will see as per to the circumstances of the case. If the case is such that the person is that the if the court is getting a feeling through the facts of the case or through the overall facts of the case that even in the case of bailable warrant, the person, the accused, will represent himself in the court of law, then the court will issue bailable warrant. But if the case is such, so especially when it comes to cases like murders or mostly in cases of cognizable offenses, the court will more go with the option of non-bailable warrant, because there are chances that the accused may run away. So this is the reasoning that the court will decide whether this is going to be a bailable warrant or non-bailable warrant. Okay. Now coming to the other provisions. Who is going to execute the warrant? The court himself, the judges himself, the court, the officer. So the answer is the police officer will execute the warrants. But it may be any other person as well. Now who can be that another person other than the police officer who may execute the warrant? That is going to be if that person is authorized by the court. So that may also execute the warrant. Now coming to the next question. Once the person has been arrested under warrant, that in that case that person must be represented before the magistrate within 24 hours. This is the section 76 is completely similar to your section number 57 of CRPC, which is basically if the arrest has taken place, then that person must be represented in front of magistrate within 24 hours. Now the question is, sir, why? So first thing is, in that 24 hours, the traveling time will be excluded. Okay. Now the question is, why within 24 hours? The answer to that question is because, once the person has been arrested, then there are several rights of arrested person as per to chapter number 5 of CRPC. Then similarly, there are duties of the police officer while doing the arrest, who is doing the arrest. Now, whether those duties has been performed, whether those rights has been exercised, okay, whether this is an illegal arrest or not. So answer to these all questions will be given by the magistrate when he will be represented before the magistrate, whether there is any kind of violence that has been used on him or not, whether the examination of the arrested person has taken place or not. So that is the case. Now coming to the last concept of warrant, and that is, what if the warrant needs to be executed and it is outside the jurisdiction of the court? So supposedly, if the person needs to be arrested in the next state, then what is going to be the procedure? Then there are two ways how that particular warrant can be executed when it is outside jurisdiction. So you can refer section 78, 79, and section number 80 with 81 as well. Okay, from section 78 to 81. So I'm just giving you the conclusion of all these sections. Okay, before that, I'm just having a look if you have any questions in the comments. Okay, no questions at all. All clear? Okay, perfect. Perfect. Now moving forward. So if the person is outside the jurisdiction, then in that case, there is a list. The warrant will be forwarded to the executive magistrate, okay, or DSP, District Superintendent of Police, or Commissioner of Police. Now, which executive magistrate, which DSP, or which Commissioner of Police? Now, we are talking about the those executive magistrate who in whose jurisdiction that accused has been present. So warrant will be forwarded to these person, and then they will further execute the warrant. But now the question is, there are circumstances when the police don't have that much of time, because there is some administrative work. It is like okay, let me make a chart for you for this one. So the thing is, let's take a simple example to understand this whole concept. So suppose there is a court A, okay, and this is the jurisdiction of court A. But the problem is that the court A wants to issue warrant against X. Now this X is outside the jurisdiction of this court. So how these warrant is going to be issued? So the court A will forward the warrant to executive magistrate or DSP or Commissioner of Police, under whose jurisdiction this Mr. X is available, and then they will execute the warrant. Now, similarly, as you can see in the chart as well, this may take the time. Okay, first the court will inform this, then they will further give to their juniors, okay, to the police officer who is going to execute the warrant. So this may take time. So we do have section 79 as well, which means in the emergency circumstances, this police officer may go directly as well. Why directly? Because still this Mr. X is outside the jurisdiction of court A, but this Mr. X is within India only. So as far as section 77 is concerned, the concept is simple, that the police officer may execute the warrant within the jurisdiction of at any place in India. Okay, but if it is a case, how you will get to know that it is a case of 79 or 78? This will tell the circumstances. So let me give you one more practical example for that. If the police officer got an information that a well-known criminal, Mr. X, is available in this farmhouse, now the police officer knows if we are going to go through the procedure of 78, he will be out of the reach. In short, he don't have much time. Then he may use the procedure of section number 79 as well. So it depends upon case to case. Any questions till now? So this is basically your warrant works like. Any questions till now? If it is clear, quickly give me a thumbs up. I'll move to the next one. And if you have any questions, feel free to ask. Okay. Moving to the next one. The next one is section number 82. Now, how this section number 82 will come into the picture? In Hindi, you must have heard about bhagoda. Okay, that is basically proclaimed offender. In Hindi, it is called bhagoda. Now, how the person is bhagoda? The summons have been failed, the warrant have been failed. If someone is out completely out of the reach, and with the use of summons or warrant, you cannot compel the appearance, then the court may use the third option, that is section number 82, in which basically they will give 30 days of time period, and within 30 days, if the person is not surrendering himself, if the accused is not surrendering himself in the court of law, then that person will be pronounced as proclaimed offender. Now, during this movement, see, there's a complete logic into it. Listen carefully. When it comes to section 82, it talks about proclaimed offender. Now the thing is, the accused is running from the law. Okay, this is basically what is going on here. The accused is running from the law. Now the thing is, what about his immovable property? That will be there only because of the nature of the immovable property. So even at the time of proclamation also, the court may attach his immovable property. Whatever the house, the land, the plots, okay, the fields, whatever the immovable property this person has, they may be attached. Now, what is the purpose of those attachment? Attachment here means, so suppose there is one house, okay. Now, whosoever may be in the possession of this house, the family of the proclaimed offender, okay, the family of the proclaimed offender, after attachment, no one can use this. This will be sealed. Now, why sealed? Why they are attaching his property? Because when the proclaimed offender will get to know about this, that all the property is going, then he may, so basically to push him to surrender himself before the court of law. So there comes the concept of attachment. But now let's take an example. If this house belongs to two brothers, suppose B1 and B2, and B1 is the proclaimed offender. Now, who will get the problem? The B2. So, can B2 claim to that particular court? Answer is yes. You may represent all your claim and objections within the 6 months of the attachment. And once you are claiming, then B2 has to represent his case that he is also the owner of 50% owner of this property. And if he convinced, he will get the property back. But what if not? Then the court will, continue with the attachment. Even in this case, if he lose B2, if B2 is the aggrieved party, he has all the rights that within 1 year, when his attachment, when his claim or objection has been failed, within 1 year of that time, this person B2 can go to the court and file a suit. I am talking about. Right now we are doing code of criminal procedure, but I'm using the word suit, which means why? Because if his claim failed under section 84, then he may file a suit, but within 1 year. The limitation period has also been given in this provision. So within 1 year, B2 have to choose whether he want to file a separate suit or not, and he can file that. Okay, but let's suppose if there are no claim, there are no objections, and still there can be two situations. Either the proclaimed offender will surrender or not. If he surrender, the court will release the property immediately. Why release? Because what was the purpose of attachment? The purpose of the attachment was such only, it's like जैसे it's like जैसे चूहे को बिल से निकालना होता है ना. This work exactly like that. कि आपने चीज लगा दिया है and now you are just waiting for the mouse. So similarly, once you have attached the property, if the proclaimed offender surrenders, then you will release the property. But now, what if not? If still the proclaimed offender is not coming in the front of the law, then you may sale that as well. Okay, and what is the concept of restoration here? So if he comes after the sale within 2 years, then he will get the money back after some deductions, after some expenses which has been incurred by the court. So he will get that amount, but only for within 2 years. So this was the concept of summons, warrant, then your proclaimed offender, attachment, and sale of the property. Now, any question? So this was basically, you can say, a kind of a summary or a quick revision basically. But I hope this helps. So anything now which is not clear to you, you may ask. Yes, please. Alaiva, Shivangi, Piyush, any questions? Okay. So let's conclude the class. So students, this is the link of my profile, my Telegram channel, and this is my code Khatri10. So let's crack PCS J with Unacademy. So this is the revamped test series. This is the revamped test series for judiciary learners, and we have a special offering this December. This is the Bihar State Judiciary batch, which has been started recently from December 8. This is the Judiciary Legends UP batch, which is going to start from December 15. This is the Plus and the Iconic prices. This is the Articulate, the magazine, which is coming soon. These are the YouTube channels of Unacademy. These are the Telegram channels of the Unacademy. And that's it from my end. Okay, Ji. Thank you, Alaiva, for the confirmation. Anything else? Anyone wants to ask anything else? So that's it from my end. So see you in my next class. Till then, yes, it's time to say peace.